The approximately 3.6 million people currently living in territories of the United States will continue to be legally considered as separate and unequal in rights to citizens born on the mainland after the Supreme Court of the United States on Monday denied a petition to review Fitisemanu versus the United States. At the center of the case is the question of whether people born in U.S. territories have a constitutional right to citizenship. The named plaintiff, John Fitisemanu, was born on American Samoa but has lived in the state of Utah for the past 2 decades. "I was born on U.S. soil," he said, "have a U.S. passport, and pay thousands of dollars in taxes a year to the federal government." Despite fulfilling this civic duty, Fitisemanu and the millions of other Americans born on territories is barred from many state and federal jobs reserved for mainlanders and is also barred from exercising what many Americans consider a fundamental democratic right, voting. Despite his long-standing Utah residency, because Fitisemanu was not born on the mainland, he is ineligible to vote in state, federal, or local elections, even as others who have moved to Utah from elsewhere on the mainland enjoy these very privileges. Quote, "This isn't just wrong, it's unconstitutional," Fitisemanu contended. The issue stems from a controversial series of Supreme Court opinions issued in 1901 called the Insular cases. Following the end of the Spanish-American War in 1898, the United States of America had to decide on how citizenship and constitutional rights applied to residents of its newly acquired territories. Ultimately, the court held that constitutional protections do not automatically devolve onto such people and gave Congress the power to pick and choose which rights and privileges America's colonial residents could enjoy. Over a century onwards, the insular decisions are widely held to be racist and a constitutional cover for the United States' ongoing colonial relationship between the mainland and the territories such as Puerto Rico, the U.S. Virgin Islands, American Samoa, Guam, and other territories where populations skew largely non-white. The language of the opinions support their characterizations as racist from a modern viewpoint, with references to territorial residents as savage and uncivilized tribes, as well as alien races. Leading legal scholar Professor Sanford Levinson from the University of Texas Law School described the insular cases as, quote, "central documents in the history of American racism." Despite this firm shift in perspective, the Biden administration last year used the insular case opinions to argue against the notion of birthright citizenship for people born in U.S. territories. However, even as the Biden-Harris Department of Justice adopted this stance, there has been pressure to abandon reliance on these widely panned pieces of jurisprudence. Last November, Justice Neil Gorsuch openly wondered, quote, "Why shouldn't we just admit the insular cases were incorrectly decided?" There have also been calls from members of Congress for the DOJ to condemn the insular cases. Further, House Resolution 279, which rejects the insular cases and the view they present on race, is currently wending its way through the congressional process. Despite the groundswell of support to reject the insular cases, they still represent the viewpoint of the American legal system as established by the highest court in the land. In January of this year, proponents of the rejection of this aspect of American jurisprudence were dealt a blow when the 10th Circuit Court of Appeals denied a petition by the plaintiffs of the Fitisemanu case the opportunity for review by the full court. Initially, the plaintiffs had prevailed in the 10th Circuit, with Judge Clark Wadup's ruling at the district level that Congress did not have the power to deny full citizenship rights to those born in U.S. territories. However, that decision was overturned 2-1 on appeal, with each judge on the panel writing a separate opinion. After the January decision at the appeals court, Equally American, which represents the Fitisemanu plaintiffs, issued a statement noting the rarity of having a 27-page dissent to a denial of a full court review. Neil Ware, Equally American's president and founder, said that the lengthy dissent demonstrated how important it was for the Supreme Court to take up the case to, quote, "finally answer whether people born in U.S. territories have a constitutional right to citizenship." However, in Monday's decision, the Supreme Court signaled that unlike overturning 50 years of precedent to restrict rights that were previously granted, as in the case of the fall of Roe v. Wade, They are not interested in overturning a century of precedent to grant rights to those born on American soil that were previously restricted. It's a punch in the gut, Fitisemanu told reporters following the Supreme Court's decision.